Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Lope TV. If you haven't already, please go ahead, hit that like button, hit that subscription button, and turn that notification bell on. I'll give y'all a few seconds to do that. All right. This video, I would advise y'all to watch this entire video whenever you can, because of what I'm going to be discussing is municipal corporations, administrative agencies, and territorial jurisdiction. That's the purpose of this video. All right. This is a Supreme Court case from Iowa. So if you are in the city of Des Moines, Iowa, this video, you probably need to go and read this case. This case is from 1896. This is why I always say you have to read the old cases. They're going to give you a history lesson. All right. So this case involved a municipal corporation annexing, in other words, seizing private property that doesn't belong to them, and bringing it into their corporate territorial jurisdiction without permission of the owner of the land. So the owner of the land, he sought a writ of quo warranto to oust them from exercising their corporate territorial jurisdiction on his land. However, there are some equity issues in here that essentially prevented him from doing it. Not only that, it's just him. It's just him. There's other people on this land too. But the fact is that in my opinion, based on reading the case, the reason it was decided against him is because of equity. He waited too long. Don't sleep on your rights. He who seeks equity must do equity, and he who comes into equity must come into equity with clean hands. And you cannot sleep on your rights in equity. All right, so they're going to be talking about a lot of principles in this case, dealing with other cases from other so-called states. So I'm not going to read everything. I'm going to try to read everything in blue and just provide y'all with some commentary on it. And then at the end of the video, I'll tell you how you can remove yourself. If I don't forget, you can remove yourself from their territorial jurisdiction. Give me a second, y'all. Let me pause the video. Be right back. All right, y'all. Sorry about that. Quo warranto, to test the right of the defendant, city, to exercise corporate authority over certain territory added to said city by legislative enactment. Prior to 1890, the corporate limits of the city of Des Moines embraced 8 square miles. All right, but this amendment amended a legislative charter. All right, such extension being so made as to leave the boundaries hereby created in a perfect rectangle, that all territory embraced within said extended boundaries, whether the same is contained in the cities, incorporated towns, or otherwise, shall be and become a part of the city and subject to its jurisdiction and authority. What jurisdiction are we talking about? Their territorial jurisdiction and authority. That's what we're talking about. The corporate character of any annexed, or in other words, any seized territory. Well, hold on, wait. No, because, so essentially what they're doing is they're enlarging their corporate territorial jurisdiction. That's what they're doing. And they're merging all of the other, I think there was about 6 or 7 towns or whatever, cities or towns. They're merging them all into one. So it's gonna discuss that. You'll see it. And the corporate character of any annexed territory within the extended boundaries herein specified shall cease and determine. So let's go down. In the added territory were only 1 city and 7 incorporated towns. These 8 corporations embraced, including 1.5 square miles of platted land not incorporated, 13 square miles, which with 33 square miles of platted and unincorporated land make the added territory of the city 46 square miles. The provisions of the act by which the municipal government, other than that of the city of Des Moines, were to become extinct, and the entire territory to become one corporation or municipality. We observed so that in April 1890 the change was complete, since which time the city of Des Moines has thus constituted and has exercised throughout said territory. We're going to say has exercised throughout said corporate territory the rights and functions of a city government. You see how they're acting like a government, including the levy and collection of taxes, establishing, opening, vacating, changing, and improvising streets. And improving streets, the making of contracts, and creating and payment of debts. And the creating and payment of debts. I'm sorry about that, y'all. Let's go down some more. So this was what I just read up here was the argument for the appellant. All right, what I'm going to read down here is the argument for the appellee. It is first said that the realtor, A.J. West, has not sufficient interest to authorize him to invoke the action of the court in behalf of the state. Mr. West is not a citizen of Des Moines, as enlarged, but he is the owner of the land within the added territory, but not in any of the corporations as they were before the annexation. Let's go down some more. The constitutional question as to the validity of the law making the annexation are important. The parties in argument concede that the learned judge who tried the case below held the law to be unconstitutional, but denied the relief asked on the ground of lashes or estoppel. All right, so I'm gonna stop right there. Lashes and estoppel are equity affirmative defenses. All right, these are equity affirmative defenses. So let's go down. Let's see. Where are we at? A lot of this stuff. I'll say our conclusion is that the act providing for the annexation is against the express provisions of the Constitution prohibiting the passing of local or special laws for the incorporation of cities and is therefore void. So long story short, they said the act was void because of that. They gave their reasons above, but I don't want to read all of that because I don't feel like it's important. The only thing that is important is you need to know is that they declared the act void for right now. All right. Let's see. All right. I had to make sure I have read that right. It is next to be determined whether or not, with the law giving rise to the annexation absolutely void, the legality of the present city organization can be sustained under the rule of estoppel or lashes. On this branch of the case, a large number of authorities have been cited, and the newness of the question, as well as the great interest involved, make it one of great importance. The foundation for the application of the doctrine of estoppel is the consequence to result from a judgment denying to the city of Des Moines municipal authority over the territory annexed after the lapse of 4 years, during which time such authority has exercised and changed conditions involving extensive public and private interests. It will be remembered that the act of annexation resulted in the abandonment of 8 municipal governments, which before the annex action were independent. Which before the annexation were independent. and bringing them under the single government of the city of Des Moines. This involved a vacation of all offices in the city and towns annexed, and the delivery of all public records and property of the officers chosen for the city so enlarged. For 4 years, taxes have been levied, collected, and expended under new conditions. Excuse me. Public improvements have been made, including some miles of street, curb. I don't know why I keep stumbling over my words, y'all. I'm sorry. I've been working so hard on a brief yesterday, and I didn't finish it until this morning, probably like 7 o'clock this morning. Anyway, sorry about that. Public improvements have been made, including some miles of street curbing, paving, and sewage, for which certificates and warrants have been issued, and contracts are now outstanding for such improvements. In brief, with the statement that for 4 years the entire machinery of city government has been in operation. The situation may be better imagined than expressed. It is hardly possible to contemplate the situation to result from a judgment dissolving the present city organization and leaving the territory formally embraced within corporate lines as it would be left. Of all the cases to which we are cited involving the validity of municipal organizations, where the consequence to result from a judgment of avoidance are considered, not one presents a case of such uncertainty, nor where there are the same grounds for serious apprehension because of difficulties in adjusting the rights in the case. They saying this is a very, very, it's a very serious case, and it is a very difficult, it's kind of difficult to adjudicate because of the mixture, or the mixture of the public rights, which is the city government, and the private rights, which is the man who owned the land. Essentially, that's what they're saying. So let's go down. Where is it? More to appear that for more than 4 years, the corporation, notice that they keep referring it to a corporation, y'all. If you don't think that they're corporations right now, I don't know what to tell you, because it ain't no doubt in my mind about this stuff, y'all. They are corporations. That for more than 4 years, the corporation has been recognized by the legislature in its acts, had exercised the powers and franchises conferred on such corporations by law, had levied and collected taxes, made contracts, and incurred liabilities, and passed and enforced ordinances. The Supreme Court declined to consider the matter of irregularity in voting and sustained the corporation alone on the grounds of the avertments of the answer or pleas. And while it attached much importance of the subsequent acts of the legislature in recognition of the corporation, it added, after detailing some consequences to result, municipal corporations are created for the public good, for the government good, are demanded by the wants of the community, and the law, after long continued use of corporate powers and the public acquiescence, the government acquiescence, will indulge in presumptions in favor of their legal existence. It would seem incompatible with good faith, equity, and against public policy statutes, although irregularities may have intervened in the organization of the town, now to hold that it was not a body corporate. We do not think the law requires us to do so. We realize the dissimilarity of the case in some respects and from the one under consideration, but at the same time, in its reasoning and conclusions, It sustains the principle that lashes may overcome legal defects in such organizations. And there's a Michigan Supreme Court case citing that, even though this is an Iowa Supreme Court case. All right. These are principles that they're going by, y'all. So if you're asking me, like I had somebody ask me about the child support thing, and they were asking me, could that, they said something to the effect that this was a New York case, and since it was a New York case, they were asking me, could they use it somewhere else or something like that, and I told them yes, because that's a principle in equity. All right. Anyway, pay attention to this part right here too, y'all. Even in private associations, the acts of parties interested may often be stopped. Even in private associations, the acts of parties interested may often stop them from relying on legal objections which might have availed them if not waived. Do not sleep on your rights. You need to act immediately when you find this stuff out. Do not sleep on your rights. Do not sleep on your rights. Do not sleep on your rights. Act immediately. But in public affairs, whether people have organized themselves under color of law, statutes are not laws. They're only the appearance of law. In ordinary municipal bodies, and gone on year after year raising taxes, making improvements, and exercising their usual franchises, their rights are properly regarded as depending quite as much on the acquiescence as on the regularity of their origin, and no ex post facto inquiry can be permitted to undo their corporate existence. They are corporations. I don't want y'all to just pay attention to the fact that they're a corporation, but pay attention to everything that I just read. Do not sleep on your rights. Whatever may be the rights of individuals before such acquiescence, the corporate standing of the community can no longer be open to question. If you acquiescence to it, have to just keep indulging in it, keep accepting it, and so on and so forth, don't do that. They're telling you right now, don't do that. So, in other words, you're not going to remove yourself from their corporate territorial jurisdiction unless you leave that municipality. But there's more. In proceedings where the question of whether a corporation exists or not arises collaterally, the courts will not permit its corporate character to be questioned if it appears to be acting under color of law, as recognized by the state as such, and the rule we apprehend would be no different if the Constitution itself prescribed the manner of incorporation. Oh, that is very interesting. They're saying the Constitution doesn't even matter in regards to this principle that they're discussing. Even in such a case, proof that the corporation was acting as such under legislative action would be sufficient evidence of right, except as against the state, and private parties could not enter any question of regularity, and the state itself may justly be precluded, in other words, foreclosed, barred, or stopped on principles of estoppel from raising any such objection where there has been long acquiescence and recognition. Thus, it is true is a direct proceeding by the state. And while the language used is applied in part to collateral proceedings, it seems also to include actions by the state directly. The learned writer sustains this text by reference to People versus, I don't even know what that case is, but People versus Maynard. it will be seen that importance is given to the fact that the defective organization takes place under color of law, meaning it is a de facto government. Pay attention, y'all. Pay attention to this, y'all. It is a de facto government, not a de jure government. It is a de facto government. It will be seen that importance is given to the fact that the defective organization takes place under color of law. Nothing less can be said of the annexation in this case than that it was made under color of law. Color of law does not mean actual law. Color, as a modifier in legal parlance, means appearance as distinguished from reality. Color of law means semblance of legal right. Is this making sense to y'all? Is this making it doesn't? So what they're saying, this is what they're saying, y'all. It doesn't matter if this government, whether it be municipal, whatever. I'm gonna say municipal. We'll go since that's what we're talking about, municipal corporations. It doesn't matter if this municipal government has been given a charter and the charter is later declared void, so the corporation is no longer in existence. It doesn't matter. As long as you acquiescence to it, equity is going to prevent you from ousting them from exercising territorial jurisdiction. That's what they saying, y'all. Notice they use the term color, and they're telling you that it's not actual law. It's not law. It doesn't give them the legal right to do it. It's a de facto. It's an in fact government. Yeah, in fact, it is a government. However, it is not, the government wasn't established in a manner prescribed as it was supposed to be. Put it like that. Man. Y'all got to read. These folks know this stuff, y'all. You crazy if you think that they don't know this stuff. They've been knew this stuff, man. It is then said that in this case, the state is seeking to assert a public interest. The state is public, you are private. So anytime you see public, you automatically presume until you see otherwise that they're talking about the state, or they're talking about a city or a county or a municipality, something other than you. It is then said that in this case, the state is seeking to assert a public interest in that it is aimed at a usurpation by a municipal corporation of powers not conferred by valid law. If that is the purpose of the suit, it will be realized if that is the purpose of the suit, it would be realized, for we would hold in as explicit terms as we can command that the act is inoperative to confer upon the defendant corporation any power or rights whatsoever. Had the act never been passed and the same method for annexation been adopted with the same conditions as to recognition, acquiescence, delays, and public and private interests involved, the same conclusion would still result. I don't think y'all understood what they just said. Give me a second. Let me get me some water. I'm going to explain that to y'all. I'll be right back. All right, y'all. I'm back. Sorry about that. Where did I leave off? Well, yeah, I was going to explain this, but I don't want to make this video. It's already 30 minutes. I don't want to make this video too long. So I'm going to read this again. I'm not going to explain. I don't want to make this video too long. I'm sorry, y'all. Had the act never been passed, and the same method of annexation been adopted, with the same conditions as to recognition, acquiescence, delays, and public and private rights public and private interests involved, the same conclusion would result. And hence, the act is without the least significance, nor have we given it a shadow of bearing, except insofar as it may have served as a color of law inducing the proceeding for annexation. But aside from this, the record in no way indicates a public interest to be subserved by a judgment avoiding, meaning a judgment voiding, the present corporate existence. Not one of the 60,000 or more inhabitants of the city as now constituted makes a complaint. I gotta read this again, y'all. I gotta read this again. But aside from this, the record in no way indicates a public interest to be subserved by a judgment voiding the present corporate existence. In other words, by a judgment nullifying their corporate existence. Not one of the 60,000 or more inhabitants of the city as now constituted makes a complaint. Nor does it appear but that all are entirely satisfied with the change that has been made. The realtor, but for whom the cause would not be in court, is not a resident of the city, but he is the owner of the land of which assessed valuation of $80, giving him the legal right to institute the proceeding. He in no way claims that he has been injured by the change, or is likely to be. The judgment of ouster against the city is claimed as a naked legal title. Had it been exercised with promptness after the power was assumed by the city, we do not see why he should not have been, we do not see why he should not have had his judgment. So in other words, they're saying if he would have acted fast, when he found this stuff out, then he could have ousted them from exercising their corporate territorial jurisdiction over his land. Another thing this is saying, y'all, if there's a house somewhere, an abandoned house, and you go to that house, but let's say you start acting reasonable, you started posting ads in the newspaper saying, hey, if this your house, let me know. If not, I'm going to go in, I'm going to fix it up, and so on and so forth like that. And you do that for like a month, Or let's say you take it even further. You start placing ads on television, telling people, hey, look, this is the house. Nobody owns it. I've been trying to find out who owns it, so on and so forth, but nobody owns it, blah, blah, blah. All right. And you don't hear from anybody. Let's say a month goes by, 2 months, whatever. We're going to say a month. A month goes by, and you start fixing up the house. You start taking care of it, investing in it. The owner of that house, this case is essentially, it's holding that, implicitly holding that. It's not expressly saying that, it's implicitly saying that. The owner of that house that you just invested that money in, that you're investing money in fixing up for it to be yours or to sell it or whatever, is barred. And if they're not barred, they have to reimburse you for the cost that you invested in this house to fix it up. If not, that's unjust enrichment, and equity is not going to allow that. I'm not an attorney, y'all. I've never went to law school. I don't want to be an attorney. But I promise y'all, all you got to do is read. You do not need to go to law school for this stuff. Let's go on. You're almost there. The conditions out of which arise the necessity for the rule we apply are not the results of the enactment alone, but of the things done by the people relying upon it. By the act, it is said that the limits of such cities are hereby extended, and that the corporations in the outlying territory it provides in terms that they shall cease and determine. The people, in making the change, acted upon what purported to be fixed conditions. And these facts strengthen the equitable claim of the city that it should not be disturbed at the instance of the state simply asserting the invalidity of its authority. So in other words, it says the people in making the change acted upon what purported to be fixed conditions. What they're saying is the people acted in good faith. That's what they're saying. Even though it doesn't say that, it doesn't expressly say that. It implicitly says that. How do I know that? Because equity is not going to permit you to act in bad faith and do that. Finally, it may be said that aside from the necessity of maintaining the integrity of the Constitution against infractions from legislative action, there is not a reason for, let me read that again. There is not a reason suggested for or a benefit anticipated from the judgment sought in the proceeding. Such a judgment would disrupt the present peaceful and satisfactory arrangement of all the people of the city as to its corporate existence, without a benefit so far as we know to any person. The law does not demand such a sacrifice for merely technical reasons. In fact, the constitutional vindication is complete with the declaration that the act is absolutely void. The judgment of the district court is affirmed. All right. So he's stopped from he is barred from ousting them from exercising their corporate territorial jurisdiction over his private property. However, they're not telling you what happened in the background of the case. You know, this guy could have met with the city or whatever, and the city would have been like, look, you know, even though, you know, you slept on your rights and you can't prevent us from doing this. We understand that, you know, this is still your property. So as to be fair, we're going to lower your property taxes to this amount or something like that. Or as a matter of fact, we're not even going to make you pay property taxes on it. Just don't tell nobody. See what I'm saying? Because they can do that if they want to. These are corporations. And he can accept that if he wants to. Because he has essentially an unlimited, and just like they do, essentially an unlimited right to contract. It's crazy. Let me pause the video, y'all. I'll be right back. I'm sorry. All right, y'all. I'm back. Sorry about that. All right. So what we've established here so far, if you watch my videos on administrative agencies and the recent videos on territorial jurisdiction and just municipal corporations in general, then you can reasonably establish and conclude, and I'm of the opinion that you would be 99% right. You can reasonably conclude that the city, the town, the county, Child Protective Services, what else? DOT, the CIA, whatever. They are all administrative agencies. All right. So in other words, they're municipal corporations. And they are exercising territorial jurisdiction over certain territories. All right. Now, how do you remove yourself from their corporate territorial jurisdiction? How do you do that? How do you do that? One, this is just my conclusion that I've come up with. You're going to have to move out of the city into a rural area where they have a less chance of claiming equitable estoppel against you that bars you from them exercising territorial jurisdiction, their corporate territorial jurisdiction. That's what I'm gonna call it. So what do I mean by that? So you move to a rural area, you purchase the land or whatever, and once you purchase this land, you need to know, or you need to automatically presume that this land is under their corporate territorial jurisdiction. And when I say there, I'm talking about the county. And even if you're near a city, I would serve everybody. I would serve any city within a 50-mile radius. I would serve the city and the county a notice of to cease and desist, or something like that, to oust them from exercising their corporate territorial jurisdiction over my land. Now, you can do that immediately. Do not sleep on your rights. Do it immediately. All right. After you do that, if they don't want to do that, then you take them to court, and you file you a writ of quo warranto in a court of either general jurisdiction. They may, I don't know what they call it where you are, all right? But generally speaking, courts of equity, which are courts of chancery or whatever, they exist independent of statutes. All right, so a court of general jurisdiction has equity jurisdiction. They can do damn near anything, almost everything, if I'm not mistaken, to give you your remedy in equity. All right. The reason you're gonna have to do that is because you do not own that land. Not only that, it's just you. So you don't, not only do you not own the land, you're just one individual who you just leave. Just leave, because you have other private citizens there too, and they have private rights. They have a private right to be there if they want to. They love it. They enjoy it. And don't get me wrong, there are some benefits to it. You feel me? So you're not gonna win in there. If the state ain't gonna win, you're not gonna win. Let me show you what I'm talking about. Right here. This is 404. Let me show y'all the case right quick so you can go and read it. This is a real good case. I wanted to do a video on it, but it's too long. So I'm gonna just give y'all the citation. Excuse me. This is from 1936. This is a Florida Supreme Court case, 1936. All right, but they're citing principles in here, y'all. Principles. They know this stuff. So let me read y'all something, man. This goes to show y'all just what I just read y'all in the other case. A state may, after long acquiescence and recognition of a municipal corporation, be precluded from proceeding by information to deprive it from exercising the rights acquired by it from general law. Thus, where a municipal corporation has been recognized by enactment of the legislature, ordinarily all inquiry into the original organization is precluded. Excuse me. And in such cases, after long continued use of corporate powers and the acquiescence of the public in them, the government in them, the law will indulge in presumptions in support of their legal existence. I just read that in the other case, y'all. I just read that in the other case. And that was an Iowa case. It is universally affirmed that when a legislature has full power to create corporations, its act recognizing a valid de facto corporation, whether private or municipal, operates to cure all defects in steps leading up to the organization and makes a de jure out of what before was only a de facto corporation. Man, these are some good cases, man. You need to move out of the city and the county. Or if you move, like, you just can't sleep on your rights. Automatically presume that you are under their corporate territorial jurisdiction whenever you move into a rural area. I guarantee if you do that, and if you cease them from exercising their corporate territorial jurisdiction over you. Ain't no statute going to apply back there. No, there will be no statutes applied back there unless you start um creating some forms of minimum contacts with them. And you don't want to do that. The way that you do that, you don't do no business with them. You create your business and you do business in that business name. All right, so that keeps you separate from the legal entity. Nobody will be able to come back there on your territory except for the sheriff. The sheriff will not be able to do anything under a statute back there on that land. Won't be able to do nothing because statutes, all legislation is territorial. Okay, statutes. That's what legislation is. It's comprised of statutes. So any type of statutory authority that a sheriff may have, she or he will not be exercising it back there because they're in a private jurisdiction when they do that. They're in a private jurisdiction. So essentially what I'm telling you is, just like you can't go into their corporate territorial jurisdiction, which is considered the public, and do what you want, they cannot do that in your private jurisdiction without your permission because you have plenary power back there. That's what you need to do. That is how you remove yourself from their corporate territorial jurisdiction. And you will still be under the law of your state constitution. You won't be under the legislature's jurisdiction. That's why statutes are not laws. I'm going to show y'all something, man. I put this on my channel today. I just start coming up with reasonable conclusions. I'm like, just think about this. If there were no statutes, there would still be law. So how can statutes be law? Make it make sense. You cannot have two supreme laws. One of them has to be law and the other one it can't be. That's just like superior courts and inferior courts. The reason why they say inferior courts are administrative agencies is because of separation of powers. So to a certain extent, you do have separation of powers. So they have to let you know that one is superior and the other one is not. So how can you have two supreme powers, but one of them is superior and the other one is not? It makes zero sense. Statutes are not laws. And I just proved it. Now, if you go over there in their territorial jurisdiction, they do have the force and effect of law. They are color of law. Yeah. If you knowingly make yourself subject to that jurisdiction, that's just like the rules of professional conduct for attorneys. That's not law. But if you knowingly and intelligently, voluntarily become an attorney or whatever and make yourself subject to those rules have the same force and effect as law. Man, look, I think I taught y'all a lot in this video. I don't think there's anybody on YouTube teaching what I'm teaching in regards to how to remove yourself from their territorial jurisdiction, except probably Yusuf. He says it. But I think I go a little bit more into detail than Yusuf does. But Yusuf does tell you if that's what you want to do, you got to remove yourself from their territorial jurisdiction and go into a rural area or something like that. He does say that. That's what you got to do. So they're all administrative agencies of the government. I'm sorry, of the legislature. They are all administrative agencies. They're corporations, and they're exercising corporate territorial jurisdiction. That's what they're doing. So look, that'll be the end of this video. Before I go, let me give y'all the case citation. So this is volume 96. What page is this on? 521. So if you go to Supreme Court volume in Iowa, you go to volume 96 and you would turn to page 521 and you'll see this case. That'll be it, y'all. The Supreme Litigant is out. Peace.